Welcome all. I'm delighted to see you here, and I know we'll be joined by others during the course of the discussion. So the International and Comparative Law program, headed by one Dean Rosa Solario, who is very kindly arranged this, and I are just delighted to welcome today Anna van Aken, who is the Humboldt Professor of Law at the University of Hamburg. She is among the leadership on several continents in both law and economics and in international law, and has been very incredibly prolific author both in European journals and in the United States. I've had the pleasure of interacting with her over a couple of years virtually in what we call a cyber colloquium on international law, and where she's presented her work and is just a terrifically productive scholar and a learned interlocutor. And so I'm very pleased to see her here today and to invite her virtually to GW to talk about her paper in the American Journal of International Law on the subject of rewarding. So thank you. I'm delighted to see you here. I'll just, the standard note, please try to stay muted if you are not speaking, and we will be taking, I think, at the end of the discussion, some questions, I believe, time permitting, and I will encourage you ultimately to put those in the chat function. Rosa, are there any other things I should announce?
Just thank you all for being here. And thank you also to Professor Swain and Professor Anna van Aken for agreeing to participate in this event. Thank you.
Okay, take it away then.
So thanks so much for the invitation. It's a delight to be there. And thanks to Rosa and thanks to Ed as well for this invitation and for organizing it. And a special thanks to Ed, actually, because this article, which I'm presenting today, we have discussed in the cyber colloquium, and that was incredibly helpful, which is really just a lesson on how important communication is when you have a draft. That's for the young scholars. You know, always go out, always discuss, take all the criticism, take it on board, and it will make your papers better. I do apologize in case there's any background noise by dogs or children. I'm in my home office, so I hope it's going to be all okay, but I can't guarantee. So this paper has appeared in the American Journal, and it's open access, and I posted the link in the chat. It's joint work with a research associate with an economist at the Institute of Law and Economics, where I do work in Hamburg. There's also, I'm going to hint you to some more discussion on that paper, which was very helpful for us. So now we might be thinking about making a book out of it, because we wanted to launch this idea to the international law scholarship, and we got so many wonderful comments on that paper that we think there's much more to it, so it may be extended. So what was the motivation for this paper? The compliance discussion in international law, as far as I have conceived it, really focused on the negative incentives for states to comply. For example, sanctions or outcasting. There's this beautiful article by Anna Hathaway and Scott Shapiro on outcasting, which basically means that you deny the disobedient the benefits of social cooperation and membership. And we argue that there is a positive mechanism, rewarding, which is indispensably linked to compliance theory, but it's under-theorized. So we thought it's not that it's not there or popping up here and there, but it's under-theorized. And given that international law is a weakly enforced system with few enforcement mechanisms, we thought that it might make sense to think about rewarding as another mechanism which we should be contemplating when thinking about international law, its compliance or the governance of international relations. We draw on rationalist approaches as well as on psychological approaches, and we provide a typology and explore the rationale, the potential and the limitations of rewarding in international law. But, you know, this is an article, it's not a book, so there are many things we have left outside, which we might think about putting it in a book. How has rewarding been treated in the literature? So what we felt is that the compliance literature has relied implicitly on rewards, namely the assumption that enjoying the benefits of cooperation are important drivers to comply with international law. And the famous Henkin speak that most of the states comply most of the time. And this cooperational benefits seem to be one of the big factors, but they haven't been explicitly analyzed as such. So there is, from the law and economics perspective, the 3 R's of compliance, which are in this book, How International Law Works by Andrew Guzman, reputation, reciprocity, and retaliation. And of course, those factors are also found in the international law literature, especially reciprocity has been viewed as a strong driver of compliance, but mostly, and also in Andrew's book, it's the negative reciprocity. So the threat of negative reciprocity, which makes the, states comply. So the positive sides are not really stressed. And we thought that it's worthwhile to look at rewarding mechanisms on their own. And they're already practiced in many areas of international law, and they're mainly found there where other mechanisms fail. So those either reputational reciprocity or retaliation, or in cases of incapacity. So we are also in a way following up on the managerial approach, which stresses incapacity of states to comply. So we think that rewarding helps not only better to understand the mechanisms already discussed in the literature, but what we also want to do is to shift the focus from a penalty-oriented system to governance mechanisms between states. What's our definition of rewards? As we understand them, they're improvements in a country's value position relative to a baseline of expectations. And penalties are the privations relative to this baseline. So what is important here is this baseline, which can shift over time, and the expectations. Now, internal rewards are cooperative benefits inside the treaty, and external rewards are benefits outside of the treaty. So on top of the cooperative benefit, which derives from the treaty itself. Those external rewards can become necessary when the benefit of the bargain or the treaty, that is the internal reward, is insufficient to induce either accession to the treaty or compliance with the treaty for some states or at a certain point of time. And of course, and Ed, you might remember that when we discussed it in the cyber colloquium, why would we then do a treaty at all if there is no sufficient cooperative benefit of the treaty? Well, that depends on what you want to protect or what you want to create. So we also make a distinction between entry rewards and compliance rewards. I'm going to come to that on the next slide, and also between tangible and intangible rewards. So that can be either opportunities for or benefits of cooperation. It can be money, it can be military aid, it can be technology, it can also be social approval, a good reputation, or the status of a country. Now, why is this distinction between internal and external rewards important? Because internal rewards certainly generate more predictability for states, but less flexibility because they should be codified. Whereas external rewards are often, not always, less predictable, but also more flexible. What we find is that in the treaties we looked at, rewards and penalties are often combined, either in treaties or in soft law. So we would extend the analysis to soft law as well. So here a little bit more on this typology of rewards. So we have rewards and penalties, and we have them inside the treaty and outside of the treaty. And I start with the penalties because that's the frame within which we usually think. So when you look at penalties inside the treaty, we have outcasting and negative reciprocity. So withholding the cooperative or other benefits within the treaty, and that's limited to the state parties, non-performing their obligations. When we look outside of the treaty, we find retaliation, which can be military or economic sanctions, or withdrawal of development aid, and fines. There's also, of course, negative reputation. The reputation, or how it's conceived in the rationalist literature, reputation is not a reward or a penalty within the very treaty, but it's more important if you look at the payout. If you look at it from a game theoretical point of view, it's the future cooperation for other issue areas of international law. So negative reputation, for example, would come along with naming and shaming. Now, when we turn to rewards, first inside of the treaty, we have entry rewards, and here we have those famous cooperative gains. Why otherwise would you enter a treaty? But we have also inside of the treaties often goodies, something like access to finance or assistance within the objectives of the treaty. So you find this in the WHO. You would find help for your, I mean, it's a public health organization. You will find help for your public health strategies, without going into the details of the WHO, but the goodies you get from the WHO are basically fostering the objectives of the very treaty. You always also have this in the Biological Weapons Convention and in the Montreal Protocol. So the assistance you get under Article 5, for example, of the Mutual Fund would help to phase out ozone-depleting substances. And then we have compliance rewards, what we call, like in the game theoretical speak, redemption, or the prospect of inclusion after previous inclusion. So again, here the baseline is important. So you would get, for example, there are a lot of treaties. Most regional treaties have a mechanism of outcasting members if they're not complying with the prerequisites. I'm taking here the Council of Europe, and you might remember when Russia annexed Crimea, the Council of Europe suspended, for example, the voting rights. So that's a sort of outcasting. The Russians have been redeemed, not for letting go of Crimea, but for more realist reasons of Russia as a great contributor to the fund of the Council of Europe, and we can debate on that. But you would have, for example, the same thing in soft law with the Financial Action Task Force. If you do not comply with the recommendations, you're going to be on a blacklist. And if you're on a blacklist, your banks and market players will be excluded from or heavily hindered from participating in the international financial market. CITES is another example where you cannot trade if you don't fulfill certain preconditions. Then you would also get compliance rewards, for example, in the Kyoto Protocol, where only if you comply, you can use certain mechanisms within the treaty. For example, within Kyoto, you could only get some flexibility mechanisms if you would comply with certain conditions. And then what I found a very interesting example is the use of positive reciprocity within, at least this is the regime of international humanitarian law, by the ICRC, the International Committee of the Red Cross, which said basically we have this negative reciprocity going on. They are not complying with IHL, so we will not comply with IHL. And they felt that that's getting too much, and they have a project on fostering the positive narratives, giving examples of where actors have indeed complied with IHL. And if you talk to Peter Maurer, who's the president, he would say, well, if you think about the law, which is mostly not adhered to, that's certainly not IHL, it's actually traffic law. It's still law, so, but still we need to make sure, since we don't have the sort of fines as in traffic law, that we find other mechanisms. Let me turn to outside of the treaty. Entry rewards we give to countries, which can be linkages between treaties or promises of benefits outside of the bargain. That's clearly the case with development aid, or you get a trade treaty if you ratify human rights or comply with human rights treaties. So the base treaty then would be the human rights treaty, and the goodie outside of the treaty is a trade treaty, for example, or development aid. So if you look at, for example, the US trade treaties, you would have a lot of those sort of mechanisms. In Europe, we had this, for example, with accession countries in the Balkans, where the EU was very clear that they can only accede to the EU if they would be fully complying with the requests of the International Criminal Tribunal for former Yugoslavia. Croatia was one. They could really only accede once they handed over the suspects and gave all the information. The generalized system of preferences is the same system, which is in a way soft law because they're not binding, where we tell states to ratify or comply with certain treaties, and then they get the GSP. Another less legal issue is, for example, the goodies the People's Republic of China would give to states if they stop recognizing Taiwan as a sovereign state. Then, of course, depending on which treaty we are talking about, you can also have a positive reputation for entering a treaty, generating future gains of cooperation. And then here, again, that would be generated by naming and praising as a means of rewarding. There are others of that too. And compliance rewards, we have examples of where you also get access to finance and assistance, and which concern not the objectives of the treaty. So you get assistance for other things than fostering the objectives of the treaty, side payments, so to speak. So we had that in the Montreal Protocol, where you had the technical aid. You also find this in the Biological Weapons Convention, where you do not only get help if there's a biological attack, you get general help and technical assistance for building up your public health system in order to deal with biological emergencies. And funnily, that has not really, we always talk about the WHO during the pandemic, and the Biological Weapons Convention somehow has been left out. And they do things like matching donor or helping countries with countries in need for technical expertise, for example, or building up laboratories or stuff like that. And then you can also think about, so some of the issues we thought about, which are not existent, we thought about which could be done. One thing which is there is the positive reputation for compliance with the treaty, generating future gains of cooperation, and that you would have, for example, in the initiative of national human rights institutions. So there is if you're a good complier, then you have special rights in the Human Rights Committee, in the Human Rights Council, special speaking rights, special seating rights and stuff like that. But you can also think about rewarding states for creating marine protected areas. And we know that this network is very important. And so it's like a contribution to a public good. So you could think about giving them some sorts of rewards. Let me turn to the rationalist analysis. So when we talk about that, and when we think about penalizing or rewarding from a rationalist perspective, it's basically two sides of the same coin. Okay, so causal analysis suggests that carrots and sticks are mirror images of each other. So absent transaction costs, it doesn't matter to whom one initially assigns a property right. Another party would pay the right holder to relinquish it, as long as both would be better off. So it doesn't matter if you're rewarding, which would lead to compliance by generating a higher payoff for compliance, or penalizing, which leads to compliance by generating a lower payoff for non-compliance. So both carrots and sticks should equally lead to the target's compliance because both means produce the same opportunity costs, so the costs of non-compliance. Now, already from a rationalist perspective, rewards and penalties do make a difference. So one issue which is always, at least for economists, very important is Parental efficiency. Rewards are Pareto efficient if they are conditional and beneficial in expectations. Okay. With conditionality, I mean, you could imagine the situation where you give a reward and then the other state doesn't comply, and then you, as a sender state, are of course worse off. So you're better off making this reward conditional. Whereas with penalties, it's always Pareto inefficient because the target is always worse off compared to the status quo. Okay, costs. Rewards are costly when material, so not when immaterial, if you're talking about intangible, immaterial rewards, and if they're then applied to many countries. Also, rewards can have third-party effects. And I was giving this talk in Russia and they said, well, but then you give the reward to Ukraine, for example, NATO membership, but for us, this is really costly. So the third-party effects of rewards, and I have to admit, we have it in a footnote, we haven't treated it sufficiently. It is a big issue. And if we make a book out of it, that's going to be a chapter. But I wanted to hint to that. Then there is also the rewarder's dilemma. So if you're a rational choice scholar in international relations or international law, you do know the sanctioning dilemma, where people free ride on the sanctioning efforts of other states. But there can also be a rewarder's dilemma that just free ride on other countries providing the reward. So we are not saying this is not there. That is a problem, certainly when we talk about material rewards. Again, if you look at penalties, they are costly on both sides because penalizing or sanctioning, depending on the form of sanctioning you take, can be costly. Economic sanctions are also costly for the sending state. Military sanctions clearly are. Then the argument that the threat of sanction is not costly is not entirely honest, because if you want to make a credible threat of sanctioning or military sanctioning, for example, that's highly costly because you need to maintain the credibility to be able to sanction. And I don't need to tell you about the billions of dollars which the US spends on military prowess, and that's the only way of having a credible threat. Now, monitoring, we believe that incentives to provide information is higher with rewards, and that's enhanced if the rewarded state has a duty of proof, because then you would come forward, if you're rewarded for behavior, you would come forward with your information. And if you then are in a cooperative relationship, that may decrease the inclination to cheat. Then with penalties, you clearly have incentives to hide or misrepresent information to avoid the punishment. And it can also interfere with sovereign rights if you think about on-site inspections or prisons under IHL or something like that. Now, let me turn to the behavioral analysis. Now, if you're a parent, you know this, right? So sometimes your intuition is just to say, no. No, 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 and you're going to be penalized if you do that. And what we know, and I guess here psychologists have been much earlier in hinting us at the issue that sometimes this is not very conducive to achieving the goals you want to achieve. So you might think about rewards as well. I'm not talking about giving a chocolate every time your child behaves well. Some issues you want to be done intrinsically. Now, taking this to international law, I do not think that rewarding impacts the normativity of law or the intrinsic motivation, but we can maybe leave this for the discussion. Now, but before we turn there, can we apply behavioral insights to states? And I keep repeating, having this discussion, it's every time easier. When I started this sort of research 10 years ago, I really had to make many more arguments to convince the audience that it does make sense to do that. The first question, and there we always have to be careful, of course, who is the unit of analysis we are talking about? Are we talking about states, or are we talking about attributed individuals? The good thing is that the Vienna Convention allows us to, or the Articles of State Responsibility allow us to attribute individuals acting to the state. And then there's, of course, the problem of realistic behavioral assumptions. So I think we have enough research now to understand that the classical rational choice assumptions are assumptions and not more than that. We know that people behave differently. So the question is whether the behavioral researchers still need to justify that they apply the same behavioral assumptions from individuals to states, or whether the rationalists wouldn't rather need to justify why they apply a behavioral assumption, which we know is in reality not there, to states. And we can discuss about Milton Friedman also in the discussion later on. And then, you know, that's always the weakest argument, but of course, psychology and behavioral economics is widely used in national law. You know this, you had one of the chief nudgers with Cass Sunstein in the White House of Obama. And it's used in IR theory. There's a long tradition of political psychology and international relations, looking at mainly security constellations. And of course, newly, the United Nations is turning behavioral, and they have a behavioral insights unit, they have an innovation lab, and there are several UN agencies turning behavioral. I myself am now starting with the counterterrorism office, and they want to use behavioral insights to achieve the goals of the UN, including the SDG. I'm not saying it's a panacea, I'm just saying it's less cumbersome to justify why we use a behavioral approach as well. So whereas the Caucasian approach, as I said, might think that carrots and sticks are mirror image, a behavioral approach would tell you differently. There are differences of rewards and penalties on human behavior. And we pick out three. So the first is the difference in perception. So rewards are likely to be perceived as supportive and positive, whereas penalties are likely to be perceived as negative and deterrent. The rewards also usually change the perception about the sending states, whereas changes about, so what is the other state trying to do to you? And rewards may help to reach agreements that are perceived as fair. Since you're giving a reward, you might be perceived differently if you're sanctioning. And for third countries, visible rewards increase the salience of law-abiding behavior, and they may encourage conditional cooperators. So those assumptions are really coming from behavioral economics. You might know the broken windows hypothesis. The more you see that nobody is complying, the less people are complying or smashing windows. That was the New York strategy of cleaning up the city in the 80s. And it may encourage those who depend on their behavior on what they perceive others to be doing. Okay? Whereas with penalties, penalties could be a cue that other countries are not complying, and penalties can be considered as unfair. For example, penalties fall on low-income countries with capacity restrictions. We also believe that there is a difference in response of the targeted country. So rewards are likely to generate friendlier attitudes toward the source country. Rewards can stimulate compliance by highlighting mutual benefits. And a substantial reward might allow a government to sell their eventual concessions as a mutually beneficial deal, so generating a more neutral setting. Whereas this trust, if you're sanctioning, you can create distrust or even hate towards the source country. You certainly will not be the best friend of the country you're sanctioning. And threats can trigger stress. Stress is supposed to reduce cognitive abilities of decision-making, and I include leaders here. And they may well result in irrational reactions in terms of benefits and costs of compliance versus non-compliance. So there is research on what stress and fear triggers, what sort of cognitive biases that triggers, and Kahneman, who's a Nobel Prize winning psychologist, Nobel Prize in economics, calls them hawkish biases, and there are several of them. I'm not going into detail here. And non-compliance can also be motivated by the trying to avoid to look weak, also towards your own internal audience, but also on the international plane. And if we turn to reciprocity, clearly reciprocity calls for returning good for good, and that may lead to compliance, whereas reciprocity also calls returning bad for bad, which may lead to non-compliance. And we believe it also makes a difference in the stability of international relations. So as I said before, since rewards are likely to please the receiver, and they also tend to invite future cooperation, that is likely to spill over to the target's willingness to cooperate on other issues. So not only on the hand in matter or the treaty in question, but also on other matters. It can support cooperation and communication is a very important factor in cooperation. It can be a de-escalatory mechanism, but again, think about the third-party effects. And intangible rewards like visits, social approvals, and praising can create trust between countries. They don't need to. If somebody of you is now thinking about the summit between the North Korean and the American president, when was it, 2 years ago? It seems it hasn't really created trust, but anyway, so that proves the principle. Whereas penalties tend to increase mutual dislike, they are more likely to reduce the receiver's willingness to have any future contact with the penalizing government. It leads to isolation, and isolation is never good for cooperation. And if a penalty or a sanction is reciprocated in kind, penalties may deepen conflicts. There are limitations to rewarding, of course, and we discussed them extensively. The most important one is probably moral hazard. That is the likelihood to obtaining a reward when returning to lawful behavior can incentivize states to exhibit undesirable behavior in the first place. Now, that can be mitigated by prior penalties for bad faith violations. So, I'm not calling for rewarding Russia to withdraw from Crimea. But we might think about the question of whether further penalties would lead to a withdrawal from Crimea. It will not. So the question is how you go. And I mean, they have been penalized as far as we can penalize Russia. But the question is how far we go. And I mean, that's obviously currently in the discussion in Europe as well as in the US, certainly in Europe. The second issue is crowding out. So psychologists and economists show that extrinsic monetary incentives may crowd out intrinsic motivation. So you think about development aid. So if you give them all this development aid, they might not be thinking about doing the things they need to do on their own. But we do know also that intangible rewards do not crowd out, they rather crowd in the motivation. So you need to be careful what sorts of rewards you're using. And then prospect theory, if we take behavioral economics seriously, there is a phenomenon called loss aversion, which basically says that if you're in a frame of loss, you become more risk seeking. So if the non-compliance is motivated by the fear of loss, threatening more loss only enhances the motivation that gave rise to the problem in the first place, namely risky behavior. When the target's non-compliance is motivated by prospective gains, the consideration of threats according to prospect theory is more effective. Okay, so those are things to think about when to use rewards and when rather to use penalties. What are conditions conducive to rewarding? We think they work best when the reward matches with the receiver's perception of what a reward is. The reward is clearly specified, credible, and will be timely delivered. The rewarder has the capability to implement the reward, because you have to also be able to credibly commit to a reward, and has a record of holding promises. And the receiver appreciates the cooperation with the rewarder, because not always do receivers like this sort of reward. It depends on what sort of relationship you have with the potentially rewarding country. And the reward follows substantial penalties in grave cases of violation. The reward is not combined with coercive measures that would cause increasing psychological costs for accepting the reward, unless you have that to deter a moral hazard. Okay, and clearly what we find in the law is that we often and mostly use rewards in case of incapacity of states, and if we are talking about treaties concerning global public goods, environmental treaties, for example. Okay, there you find a lot of those mechanisms. So to conclude, rewards generate mutual benefits, but are costly when applied to many countries if tangible, but they are Pareto efficient. Monitoring and fact-finding, which is gaining ground in international law, should be more successful when using rewarding rather than penalties. Rewards should be more efficient to deal with missing capacities, of which we have plenty. And psychological insights show that rewarding and penalizing differ sharply in the individual's behavior. And of course, states are composed of individuals. So although the costliness of penalties and also the ineffectiveness has been thoroughly discussed, especially sanctioning, economic sanctions, including targeted sanctions, unfortunately, it remains at the forefront of academic discussions and policy. Forgoing rewarding as a potentially additional effective mechanism to induce compliance would be a mistake in our belief, since international law is a weakly enforced system. And many ways of using rewarding are possible, and more research is required. So we touched upon some of them in our article, but we were hinted to other ones. There were two discussions on this article, one on Völkerrechtsblog, which is like a German blog, but it's in English, and they used this lollipop sign, which I really like. And the other one is an Agile Unbound, which was put together by Jeff Danoff, and with, I think, excellent contributions, not always positive, but I think excellent in order to do what we wanted to do with this article. And this is basically induce a discussion on the merits and the pitfalls of rewarding in international law. Thanks so much.
Thank you very much for that wonderful talk. I want to encourage people to pose questions at this point, and as a moderator, I'm going to exercise my privilege of turning immediately to those questions, and rather than hear my own voice. One question we have already in the chat, which I'll read quickly, is from Professor Murphy. I'll proceed in order. You can also just put the question in there, and I will call on you individually. Professor Murphy's question, if he doesn't mind me paraphrasing it, is that there's discussion in the US that citizens don't necessarily understand the benefits or rewards they get from government programs, and thus don't support them as much as they might. And he asked, while recognizing you're looking at this from outside the United States, is one value of identifying and articulating rewards that it might engender greater support by US citizens for US adherence to treaties, international organizations, and other international law? you may be on mute.
Yes, I think now I'm unmuted. Yeah, okay. Oh, yeah, I just tried I sometimes didn't. So I take the question of being whether we should be rewarding the United States for complying with international law or not violating, or I'm not quite sure how to.
So I think Sean, do you want to? I can paraphrase your question, but you may want to take the floor.
Well, it might actually be a bit of a softball question, Anne, but what I was getting at was, and I didn't hear you speak about this, the recognition by citizens, by people, that there are these rewards. It seems like that might generate greater support, particularly in the United States, to adhere to treaties like the Law of the Sea Convention, to stick with international organizations like the World Health Organization, and so on, if they understood the rewards. And I'm kind of thinking you would agree with that, but I just didn't hear you talking about it as one of the values of this excellent paper that you've done. Thanks.
Thanks so much, Dean. I think that's a very important question. That's again something we didn't really, or we touched really only very superficially. What do rewards do to the internal audience? And I agree with you. Sometimes, you know, we think, and especially from here, we look at the United States and say, why don't they see what some rewards can do? You know, just purely domestically speaking. What we know is that if you have sanctions, there is this rallying around the flag effect. So citizens usually tend to rally behind the government, even if the government is violating international law. So that would be an issue to explore. Whether with rewards, it may be the contrary, and they would say, well, if we could get that reward, maybe we are not happy with our government violating international law. That would be something to explore. Honestly, I haven't seen research on it. We haven't done it in this article, but this is I think, a super important question, and would lend itself to actually some sort of experimental research, which I probably should do with Adam Chilton, because he's very good at doing those things. You know, how would people react to a violation of international law? Or if you presuppose there is a violation of international law and there is a reward versus a penalty from the outside world. So that's super interesting, but again, we need more research on that. What we think is true is that it is easier for a leader to accept a reward to come back into compliance and to sell it to its domestic audience, to his or her domestic audience, than if you give in after a sanction.
Great, thanks, Anne. Much appreciated. And it is great to have you here, so thank you.
Thanks, Jim.
Dean Solaro has two questions. Would you, I assume you're able to see them in the chat, and perhaps you wish to react to them that way. One concerns the issue of partial compliance and whether that might also benefit from a rewarding scheme. And the other has to do with whether you could say a few more words about how rewards work in achieving compliance with soft law.
Thanks so much. Also great questions. So partial compliance is very interesting because, of course, and here we are in a way superficial in the article. Compliance and what exactly compliance is of course a whole library in itself. It's not an easy term, but let's say you can you can say clearly there's partial compliance, and then this comes back to the question of conditional rewarding. So I'm not saying, you know, you have $100 to give, and you give it once you think there is compliance. That all depends on the treaty. So you could think about rewarding in little steps, for example. For partial compliance gets, $1. Now I'm talking about dollars, but just to make the case clear. And then if you have more compliance, you get a little bit more or something like that. But really that depends on the treaty and how to measure compliance. But it doesn't have to be an all or nothing approach. It can always be partial as well. And soft law, I would think basically in the same way. So soft law can be very forceful. If you think about the Financial Action Task Force, or if you think about the Kimberley process in the trade of conflict diamonds, that's all soft law. It's incredibly powerful. It's clear that the Kimberley process, even though not perfect, has been more successful than the UN Security Council sanctions on trading in conflict diamonds. Why is it so successful? Because you can outcast the people who are not complying and the states who are not complying, including all the other actors which are involved in diamonds and diamond trading, out of the market. You shut them out of the market. CITES does something like that. The Basel Convention on Hazardous Waste has the same things. So, but you have it in soft law and you have it in hard law, this mechanism. And this mechanism is very, very forceful. But it's even more forceful if you know that outcasting those states is not final. You can be redeemed once you come into compliance. Okay, and that, interestingly, we find the same thing in experimental research when we talk about public good games. So you shut people out, but you allow them to come back in. And that is a positive incentive to comply. So soft law has exactly the same mechanisms as hard law or treaty law. Hope that answers the question.
We have a question in the chat concerning the effect of rewards on third parties, and it provides the example, rewarding Russia, creating an effect on states like Ukraine, Georgia, and others, even if the rewards aren't tied to the conflict in Eastern Ukraine. I know you address third parties somewhat in the article, but I don't know if you wanted to elaborate on that.
Yeah, well, we actually have, we haven't addressed it sufficiently. This is why I said before, I think the third party effects are highly relevant and in certain constellations. Okay, so the Russian-Ukrainian issue clearly, so be it rewarding Russia for being nicer in the East Ukrainian conflict, or rewarding Ukraine, for example, giving them NATO membership or the EU association agreement, which, stirred up this whole conflict, clearly angered Russia. And they thought this is a third party effect. It's costly for them because it's basically taking a country away from their sphere of influence. So I think in a book, what I would do is to try to figure out under what conditions those third-party effects of rewarding are negative or positive. If you think about a treaty which concerns global public goods, like environmental treaties, if you have an award and that fosters compliance, everybody else benefits as well from the reward because there's more provision of the public good, okay? So it really depends on the constellation you are talking about in which the third party effects are either negative or positive. But we haven't spelled that out in the article and we would need to spell that out in a much better way.
I wonder if I might ask a question about sort of regime design or the architecture that you envision. I know this isn't something you focus on in the article, but my intuition would be that penalty schemes are things that are well addressed in the design of the initial regime, in say a treaty, among other things for giving prior notice, but also as a way of broadcasting to states on the cusp of ratification or accession what the deal is exactly. Whereas I could envision rewards as being effective, not only if they're ad hoc, but also if they are spelled out in sort of a conference of the parties, say 5 years hence, or in a successor treaty. And I wonder if there's something to kind of the staging of these two that may be critical deciding whether you're going to emphasize one or the other.
Yeah, I think it's interesting because, I mean, you know, what we do, of course, distinguish is the time of for example, ratifying or acceding to a treaty and the compliance stage, and interests change. So it could be that you have an interest in that treaty at the time of ratifying, but not later. So what sorts of rewards you'll give. And then I think, again, it depends on the treaty. So if you think about a multilateral treaty, if you talk about COPs, I guess if you see that certain issues are not the way they should be, you might think about introducing rewarding mechanisms later on. And one way to do that is, of course, working with protocols. And, you know, I mean, just as a behavioral, from a behavioral perspective, it is interesting to consider if we, especially if we talk about environmental treaties, to make protocols an opt-out issue, not an opt-in issue.
I want to defer to others who might have questions before asking any other ones. I wonder if then I might say a modest word in favor of penalties in the following sense. I think that from a rationalist perspective, you're entirely right that penalties aren't Pareto efficient. As you said in the table, you know, you could almost just say that follows from a rationalist assumption. But my suspicion is that in the semi-real world, what happens a fair amount is that non-compliance is an inefficient choice in the first place. And other states are effectively signaling to the state that is making the decision not to comply, this is not genuinely in your state's best interest. This may be in your short-term political interests or something like that. And we are signaling that, you know, we know best, in effect, as to what your state's long-term interests are. And I wonder if that modification to the set of assumptions redeems penalties much in your view, or whether they're still in the same difficult position they began with.
You know, but problem is, and that's probably a little bit the problem with the rationalist approach. We think we can rationally determine or tell people what's in their best interest to do, but they may not do so. It's our perspective. And then, you know, there seem to be, and that can have different causes, could be purely rational self-interest of governmental leaders that states do things that they shouldn't be doing, certainly not good for the population, but maybe good for the leader. But there might also be something that states do value their autonomy or sovereignty, as we call them. Individuals value their autonomy, and states, so they don't like to be told what's in their long-term interest. And now it reminds me a little bit of, which I find it a bit overblown here in Europe, is the whole discussion on the legacy of colonialism, because clearly there was an interest in colonialism, but then there were also many things where colonialists thought they're doing some good, like, you know, building infrastructure, having a nice bureaucracy and all this sort of things. Was that in the long-term interest? no matter how you try to define that it's good to have an infrastructure or it's good to have a functioning bureaucracy, that was clearly not what those states wanted. So I might be going too far in order answering your question, but I just wanted to make clear the principle that I think we cannot. It's very difficult. It's very difficult. You know, we try this, and the United States tries it and tried it. You know, think about Afghanistan. We think we know what is in their long-term interest. Working, you know, having a functioning democracy, creating rights for women and all those sort of things, having a functioning rule of law. And then it didn't work. State building didn't work. And they might not want it. And, you know, in Europe, we have this discussion. What about the Hungarians? What about the Poles? We think that rule of law is a good thing to have. They're still, the majority seems to be to continue to support parties which are destroying the rule of law, their freedoms. And that comes back to what Sheen has said. You know, sometimes people seem not to either not understand or want certain issues. And we either explain better, or I guess we have to accept. And the same happens with states. So I'm not sure whether that answers your question or whether I have been going too far and correct me if you.
No, it does. Thank you. It addresses it very nicely, and I think situates this in the scope of real serious political problems we're coping with and observing both here and abroad. This is to run till 1 o'clock, I believe, and I know that some of our participants, myself included, have to go to classes soon. But I just want to say that we're just so grateful that you were able to join us today and to continue conversation on this. I mean, I'm sure I speak for others in saying that and this may be an unwelcome burden to you, and I don't know whether you regard this as a penalty or a reward, but I can't, you know, I really look forward to seeing you expand this project into the book form. I think it'll be great, and I think you've already contributed so much to this field.
Thanks so much, Ed, and thanks again to Rosa and you, and also for all the wonderful questions, and thanks for joining. And, you know, the questions I'm now putting down more ideas and more thoughts about it. So you'll find it all with a big thank you if there is going to be a book.
Thank you so much, and thanks to all for participating today. Take care. Thanks again.
Thank you.
Thank you all.